thank you for the opportunity to be here, and I will try to be as much as it's possible short in my presentation. Thanks to my previous colleagues, because we already mentioned a lot of things that could be considered similar in both, in Slovenia and in Serbia as well, and Croatia as well. So, as regards the constitutional framework in Serbia, I would like to remark that the Constitutional Act has three types of provisions which are of importance for this matter. First one is right to healthy environment, and I will repeat it a bit later. The other group of provisions are those that treat healthy environment as a reason for restriction of some other rights. And third group of provisions are provisions that regulate competence for environmental matters. Besides this constitutional framework, because Constitutional Act just put the basis and others we need to bring the laws, in Serbia there are almost 20 laws, environmental package, let's say that way, and 270 bylaws. So, from that respect, I would like to highlight law on environmental protection, law on environmental impact assessment, a law on integrated pollution prevention and control, law on strategic environmental assessment, and last adopted last year, yes, law on climate changes. As regards criminal framework, I have to say that we have 17 crimes regarding the environmental protection. I don't want to read all of this, don't be afraid, but I would like to highlight something else, and that is weak impact of criminal code. In some report regarding the EU Commission about Serbian development regarding the European Union, we got very high scores, not just because, but in this point of criminal codes, criminal offenses and environmental protection. But the result is that there is almost no one is punished, or the punishment is very weak. There are several reasons for that, but I wouldn't elaborate it right now. Second, or third, whatever part of the legal framework could be considered from civil law, and in this regard I would like to say almost similar things, and Professor Juhart did accordingly. So we all have common tradition in the part of law and obligations, so we have all those actio popularis, and what is practical side of this legal framework is that almost never is used as actio popularis, but rather as actio in some particular interest of the persons regarded. Administrative law is much complex regarding the regulations, because there have a lot of bylaws, other decisions, etc. And I would like to highlight, according to impact, of course, regulations and inspection supervision, because we could consider this activity as very important, and a lot of inspections doing their job could prevent some kind of endanger of environment protection. And of particular relevance for the administrative law could be considered impact assessment procedure. And this procedure could be has three phases: deciding on the need for impact assessment, that means not for all projects, determining the scope and content of the impact assessment study, and deciding on giving consent. But I would like to stress some fact. For example, documentation usually is very large, even there is obligation to put it accessible to the public, but documentation usually has more than 500 pages with experts' opinions, etc., and no one would like to read it in order to be informed on environmental conditions regarding the particular project. As regards, I'm turning back to constitutional framework, as regards the rights related to political freedoms and environmental protection, there are several rights that could be directly linked to environmental protection. First one is right to information, as I already explained, because we ratified Aarhus Convention. From that side, we have an obligation to make it publicly available, all informations which are of relevance for the environment. But even before we ratified, Serbia ratified the Aarhus Convention, we have already legal basis for this. That was within the definition of the healthy right to healthy environment and the right to information as a constitutional right in our act. And the importance of environment is very visible through those provisions that regulate some other rights. For example, I mentioned right to information, but it is directly linked to a healthy environment. But we have, regarding the media right, I guess that everywhere there are some reasons that you could limit media and etc. But there is exception that competent court could bring in order to prevent the dissemination, never put environmental info like information that you shouldn't spread. As regards the freedom of association, citizens could gather around the common interests, and that interest would be directed to activities on improving and keeping healthy environment, fair trial, and other rights that we already mentioned in some previous presentations. As regards actors of the formation of constitutional law and constitutional jurisdiction, of course, Parliament, Ministry of Environmental Protection, Protector of Citizens, Commissioner for Information of Public Importance and Personal Data Protection, Constitutional Court, and ordinary courts. Article 74 of the Constitutional Act of the Republic of Serbia, named Healthy Environment, provides exactly that everyone shall have the right to healthy environment and the right to timely and full information about the state of environment. Everyone, especially the Republic of Serbia and autonomous provinces, shall be accountable for the protection of the environment, and everyone shall be obliged to preserve and improve the environment. That is the definition of environment. Actually, healthy environment as the right, but healthy is not defined by the Constitution Act, but by the other laws that regulates the matters of environment, actually law on protection of the environment. Regarding the basis of fundamental rights, we could mention right to employment, working rights, where working conditions could be in accordance to healthy environment, health care, of course, and protection of consumers, where the particular attention is paid by the question of environmental or healthy environment packages and etc. Constitution provides that everyone shall be obliged to preserve and improve the environment, but the Republic of Serbia and autonomous provinces is accountable for the protection of the environment. As regards natural resources, Constitution Act regulates the restriction of entrepreneurship, proprietary rights of foreigners, and special state assets. According to Article 87, natural resources, goods which are stipulated by the law as good of public, you can read it from the slide, but I would like to stress that even a constitutional act regulates state assets and put natural resources and goods within this constitutional regulation. It's very interesting that if you read those other laws that regulate more or less the similar matters, it is used different terminology. So somewhere is natural resources, somewhere is natural goods. It's not very precisely divided. Everyone shall be obliged to protect natural rarities and scientific, cultural and historical heritage, as well as goods of public interest in accordance with the law. Law on protection of nature, last amended 2021, that means last year, but adopted 2009. In 2009, nature is determined as the unity of the geosphere and biosphere exposed to atmospheric changes and various influences, and includes natural goods, natural values that are expressed by biological, geological and landscape diversity. According to this, the law on protection put those natural goods through three categories: protected areas, protected wild species, and movable protected natural documents. Some provisions on natural and natural rarities and resources are in law on environmental protection as well, and this law is last time amended in 2018. As regards future generations are not expresses verbis mentioned in the Constitution of the Republic of Serbia, but future generations as category. In some provisions, it could be recognized, even mentioned, but not in Constitution Act, not even in other laws. But in some provisions, just mention future generations, but not just specific category or value. Anyway, I had to notice that all those provisions on matters, environmental matters, so future generations matters, has exactly that ratio legis. The Constitution Act expresses just the provisions on competence, and the Republic of Serbia shall organize and provide for sustainable development, system of protection and improvement of environment, protection and improvement of flora and fauna, production, trade, transport of arms, etc. And the provinces and local self-government have numerous of delegated competencies regarding the environmental matters. As regards other values, my colleagues previously mentioned, and the same situation is in Serbia as well, special protection of children and maternity, and supporting procreation. So even in Serbia, Constitution Act stipulated shall encourage the parents to decide to have children and assist them in this matter. Even everyone has the freedom to decide whether shall procreate or not. I have to say at this place that in this part of, let's say, our matters, future generations and environmental protection, there are a lot of measures that wrote. For example, Ministry of the Health approved unlimited, free of charge attempts for the artificial fertilization, and during the years those limits, actually conditions, are much better than it was in history. Apart from this, for example, mothers got, actually, they can apply for the 20 euros in order to buy a flat if they give birth from 1st January 2022, in order to make their lives comfortable for her and for the child, not for fathers, as for mothers. And etc. And in this part, we have the measure where, in order to protect rural areas, in one part of our history, I'm not sure that this measure is still valid, that families who decide to live in villages, they got for free, for example, houses. And then they try to support them to live in villages. And as regards Christian culture, I could repeat everything that we heard at the beginning of this conference, but I found out that in Serbian Orthodox Church is established a special committee at the Holy Synod that will deal with marriage and family, as well as committee for bioethics and ecology. That means that Serbian Orthodox Church is involved in these matters in some active way. As regards financial sustainability, I would like to say that public debt in Serbia is limited to 45% according to law and budget system. And I think that for 10 years we have public debt more than 45%. The other fund that could be of interest for those questions is Green Fund. That is in 2016, yes, established, and the idea is that it is budget fund, but the idea is to be used to finance all projects related to environmental protection. There is some information on their use of Green Fund. It's not very wide use, but in major part it's used for recycling. But it could be used for everything, but I think that citizens are not properly informed on their abilities to use it. So, protection of national assets in the Constitution is regulated by Article 87, and public assets includes natural resources, goods which stipulated by the law as good of public interest, and assets used by the bodies of the Republic of Serbia, as well as other things and rights according to the law. And law on public assets, among those things already mentioned in Constitution Act, stipulates rights such as patents, trademark, other industrial property rights, and it could be of interest for the environmental matters, at least where the patents are in question. As regards natural resources, the law on public assets provides that the use of those resources are regulated by special laws. Preservation of natural values and cultural heritage for the future generation and present generation, or due care to save it for future generations, could be considered as ratio legis for all those laws and bylaws in number that I already mentioned. Thank you a lot for your attention.